Ụmụnne m ndị Biafra, anyị ga-anọ ka mmiri baa anyị n'anya, ka ncha baa anyị n'anya. Anyị ga-anọ na mmiri ncha baa anyị n'anya. Anyị ga-anọ na mmiri ncha baa anyị n'anya. Anyị ga-anọ na mmiri ncha baa anyị n'anya. Ndị Igbo ji dị ebube. Ndị Igbo ji dị ebube. Ndị Igbo ji dị ebube. Unu ahụ n'otu ndị artificial silent ha. Anyị ga-anọ na mmiri ncha baa anyị n'anya. Ndị Igbo, anyị ga-anọ na mmiri ncha baa anyị n'anya. Chukwuamankwe. Ndị Igbo, anyị ga-anọ na mmiri ncha baa anyị n'anya. Chukwuamankwe. Anyị ga-anọ na mmiri ncha baa anyị n'anya.
regulatory space in the context of ethical framework. Ethics should drive regulation beyond what we see at the moment. About the framework that we have at the moment, context should drive ethical framework. It is a context in which content
Anyị ga-anọ na mmiri ncha baa anyị n'anya.
that should guide regulation beyond what we have at the moment. What we're having is a situation where regulators think of more of punishment than strategic partnership.
As Nigerian British,
To have regulators
Britain government free our president
encouraging
of the United States of Biafra government, Nnamdi Kanu, reason of concerns in Nigerian DSS, intending free him now before he is too late. They will free him.
there is no incentive for compliance.
Ụmụnne m, anyị ga-anọ na mmiri ncha baa anyị n'anya. Ọ ya ka m na-ajụ.
About is punishment. And regulation is not about punishment. Regulation is about
Ile ka ihe kwuru eme, ma ọ dịghị ntị ya. Ụmụ ntị ya eme.
without any so number one,
The judge gara ịjụ Tinubu ihe ọ ga-eme.
regulation.
The judge gara ịjụ Tinubu ihe ọ ga-eme.
To some extent, despite what they say, each of these regulatory bodies to which traditional broadcasters are compelled to obey operate in silos. The regulations that upright will turn out may counter the regulation that NBC will turn out. Meanwhile, the traditional broadcasters are forced to now be divided between two regulators with counteracting regulations. I can give you an example. AFCON says no content in this country, no content that is revolving within the Nigerian space should be without
Hmm. Kano has been forcefully convicted of terrorism. This has been nothing but a showing trial to try to try to trivetedly judicial mm, sympathizing sympathizing witness have lied due to process has not been abused legally, tempted underfoot, or an anarcho government increasing their political opponents, thereby destroy democracy. Ka ụwa onye ọcha ahụ aka ifuru gị aka ifuru gị ifuru gị ifuru gị mm, ka ọ dị ha abịala dịka ha abịala abịala. Ezigbo nwoke onwe na ga-eme gị onye ị ga-enye m copyright na ahịa m biko eji m Chineke rịọ buru ibu gị gawa buru ibu gị gawa
national cohesion and national security. We might need a presidential executive order which will establish a national framework for ethical broadcast and digital content governance. This is critical. As I round up, it's already standing on my head. Let me say this. Complying with ethics is not moral charity. It is a necessity to keep a safe environment. It is not moral charity. It is absolutely important that practitioners have the guardrails of ethics for their own sake and the sake of the wider society. Because where ethics does not thrive, content does not thrive. Misinformation spreads. We have narratives spun around misinformation. We have two realities coexisting. We have two sides of content, and we control fake news on a basis of ethics. Thank you very much. Thank you so much. Welcome to your next segment. Welcome to Newsroom. All right, so we've gone through three different episodes. We started off with Tony Ikara, who is chairman of the Nigerian Broadcasting Association of Nigeria. Moved on to Professor Armstrong Mbachaba, and we also moved on now to Dr. Nnamdi Kanu. So earlier on, we did have a question on how to simplify broadcasting. I'd like you to help me fill this in and proceed to your next segment. Left, right. Do we have any questions?
Questions, anyone?
Okay.
Right, ladies and gentlemen, any questions for me? We just have to move on to the next agenda in our program here, and that is the internet. Of course, I'll be handing over the mic to our president, Alhaji Dr. Tijani Ramalani.
A round of applause. Thank you very much.
Thank you very much. Mrs. Guys have done a very good job, and also this is the opportunity to thank the program presenters, Mr. Mbachaba, our friend and vice chairman from Kogi, Tony Gara, the lady that delivered the usual cover here is Rai, and also the other gentleman from Europe. Thank you very much for the excellent presentation. Also, last one is Titi Hassan. Very interesting, and I'm happy with the level of ambitiousness you have put forward, and I hope the repertoires
otu nwa otu nwa ndewo
Ndewo. Onye ọbụla kene na mmeri wo nke anyị. Akwụ ya? Ọ na-ebe iwu ha nọ. Eji ala ha n'iyi.
Exactly.
Thank you. Ndewo.
Man, that push it.
Akwụ ya? An order. This motion, my Lord, was filed on the 12th day of November, praying this honorable court for the following reliefs. An order referring the substantial constitutional questions raised in this trial to the Court of Appeal pursuant to Section 2952 of the Constitution of the Federal Republic of Nigeria, and an order staying further proceedings pending the determination of those referred questions. The supporting affidavit was deposed to by my younger brother, Prince Emmanuel Kanu, together with all annexures. My Lord, my written address filed in support of the motion, wherein I adopted and argued the three jurisdictional issues submitted to your Lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My Lord, I respectfully urge your Lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my Lord, my contention is very simple. That ab initio, this court lacks jurisdiction to try me, that this very court is a material defiance of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, and which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this charge sheet, my Lord, nullifies this entire proceedings completely and totally, because count 7, my Lord, does not exist in the laws of this very country. When I reply on points of law, I will make specific references to the ratio that came down from the Supreme Court, where my Lord Lawal Garba explicitly stated that count 7 should be changed. That hasn't been done, my Lord, and this court is in contempt of the Supreme Court binding order. My Lord,
Mazindewo, Otunwa, Otunwa Ndewo, thank you so much, thank you so much, thank you so much, thank you so much, God bless you. Otunwa, Ofunwa, Ofunwa, Ofu mkpụrụ anya ji isi ụgwọ. Ndewo, Ndewo, thank you so much.
In this very country, that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist. My Lord, do not forget.
Defendants,
My Lord,
consultants, can you tell your...
my Lord, I'm not, please, let me finish. It's my case. It is my case, my Lord, let me finish. My Lord, in this very court, Emeka Itiaba SAN was here, my Lord. Emeka Itiaba SAN said, at the right time, we will contradict or controvert a piece of evidence. A piece of evidence given in this very court. I need to write my final written address, my Lord. I must.
Which does.
My Lord, my Lord, I'm saying it clearly. I am entitled to final written address. What is my final written address? It's in the Constitution. My final written address. My Lord, my final written address. Where is it? I'm not, my Lord, please.
Can you listen to the court?
Please, my Lord, I need to file my final.
Una amana na ihe mega here. Onye ọbụla a na-egbubekwane gị egbu. You have the right to defend yourself from your enemy. Onye mega here. Yọgbashi nkịtị ndị agwọ ya ji na aja. Yọgbashi nkịtị ndị agwọ ya ji na aja. Onye unu kwesịrị ime understand. Yọgbashi nkịtị ha agwọ ya ji na aja.
I appeal to you to compose yourself this temple of justice.
My Lord, you are biased. You are biased. This is not law. You are biased. It's not law.
Please, I beg you to comport yourself.
My lord, this is not law. Show me where it says you can waive my right to final written address.
I beg you to
Show me.
comport yourself.
Show me where it says you can waive my right to final written address. And I'll sit down. Show me. My lord, you are conducting their case for them. You are the one running their case for them. Let them show me that the prosecution. Show me where it says you can waive my right to final written address. And I'll sit down.
You have the right to appeal after.
No, my lord. This is a perversion of the cause of justice. This is not law. It is not law.
Can you excuse me?
My lord, I cannot excuse nullity and illegality.
Can you let him
It's not possible. It is not possible, my lord. You must show me where the Constitution says you have the right to waive my written address. You must show me.
excuse him?
Show me. Show me where it says so. Show me. Show me where it says so.
Excuse him.
Is that why you brought the cameras? Is that why you brought them today?
Please,
You didn't bring it before. You brought it today.
please.
Show me.
Yes. Please, Registrar, first make the usual announcements.
Please kindly switch off your phone. Tell name and any other words that are not English words. The court is fully automated. The court is not right. Please, we appreciate if you know your right of discussion in order not to interfere with the proceeding of the court. Finally, comply simply with Article 1. Judgment in charge number FNC/MBJ/CR/383/2015 between Federal Republic of Nigeria vs. Nnamdi Kanu. Defendant is present in court.
Appearance takes place.
Respectfully, my lords, my name is Adegboyega Awomolo. My lord, ADEGBOYEGA Awomolo. AWOMOLO. Suraj Saida SN SURAJ SA-EDA Mutalibi Adebayo Ojo MUTALUBI Ojo OJO Adebayo ADEBAYO SAN. Lord, appearing with us for my learned friends, SH Bakun BARKUN, Abbas Olaiwola AWBAS Olaiwola OLAYIWLA Akinyosoye Arasoyin AKIYOSOYE AROSANYIN. Is Madi here? Right. The last but not the least, Ayode Jafolabi, AYODEJI, AFOLABE, BI. My Lord, we are preparing for the prosecution. Thank you, my Lord.
Yes, defendants.
Mazi Nnamdi Kanu, Mazinnamdikanu, appearing pro se. Thank you, my lord.
Thank you. Before I delivered the judgments, I think it's just unfair to call the defendants because after the judgment was reserved, while reading the file, I observed that some processes were filed. Defendants, can you identify these processes and let me know what you want to do with them?
I am most grateful. We have joined issues on the motion on notice, my lord, asking this very honorable court to refer certain substantial constitutional questions arising in this very trial to the Court of Appeal. That's the first one.
Defendants, please.
My lord.
Why you identify your motions? Tell us the date on the motion and the date you file self.
Thank you, my lord. Most respectfully, my lord, this motion on notice was dated and filed on the 12th day of November 2025. An order, my lord, praying this very honorable court to refer very, very substantial constitutional questions raised in this very trial to the Court of Appeal. It is a constitutional application, my lord, firmly anchored on section 295 sub 2 of the Constitution of the Federal.
Please identify all the pending motions.
All the pending ones, I will, my lord.
Identify the one dated on file 12th day of November. Can you identify them one by one?
It is a motion on notice, my lord, brought pursuant to sections 1 sub 1.
Identify all the motions.
That is exactly what I'm trying to do.
Identified one.
The next one is a notice of the defendant's commitment to file a final written address. This was filed on the 11th day of November and dated on the 11th day of November 2025. That is the second one, my lord. Dated 11th day of November 2025 and filed on the 11th day of November 2025, my lord. Those are the two applications before this very honorable court.
Get me the second one. Dated on file 11th. There is another one. I don't know whether you want to abandon that one. It was filed on the 17th November.
That will be the motion to arrest judgment, my lord.
It has to do with motion for bail.
That is also there, my lord. I was hoping
identify them so that I know the number of motions I'm taking. Okay. You have identified two.
Yes, my lord. This was dated. That's the motion for bail. dated the 17th day of November 2025. Sorry, dated the 25th, is it? Yeah, 17th day of November, and filed on the 17th day of November, my Lord. Those are the three motions I wish to move.
Yes, counsel to the prosecution.
May it please your Lordship, we filed a reply.
Are you ready for those?
Oh, I am ready to argue the motions.
Thank you.
Thank you, sir.
In interest of justice and in order to save judicial time, the three motions as identified by defendants are hereby consolidated for hearing. Defendants, can you proceed? Move those three motions.
Thank you, my Lord. I shall move the motion on bail last. Move the most critical ones first. Here is not enough to contain my paperwork, so it's a bit muddled.
Can I tell you one of your legal consultants to move to you?
Please, my Lord.
Mr. Ejimako, can you move to the defendant you consult for?
The person mentioned the Diego said the Diego from the place. You say, oh, that's the rice or 350. Oh, that rice is 350. Anyway, every day, cook rice 350. No, Chinese same rice. Chinese, women that they drop across, that can be a lot. The other one, what they call one kind basmati rice, it's 5 kg, every 300. So.
An order. This motion, my Lord, was filed on the 12th day of November, praying this honorable court for the following reliefs. An order referring the substantial constitutional questions raised in this trial to the Court of Appeal pursuant to Section 2952 of the Constitution of the Federal Republic of Nigeria, and an order staying further proceedings pending the determination of those referred questions. The supporting affidavit was deposed to by my younger brother, Prince Nnamdi Kanu, together with all annexures. My Lord, my written address filed in support of the motion, wherein I adopted and argued the three jurisdictional issues submitted to your Lordship for your determination. There was also a further and better affidavit and my reply on points of law filed in answer to the respondent's counter affidavit and written address. My Lord, I respectfully urge your Lordship to deem all these processes as argued and to grant the reliefs exactly as set out on the motion paper. And in a brief overview of what is contained in my motion, my Lord, my contention is very simple. That ab initio, this court lacks jurisdiction to try me, that this very court is a material of an appellate court judgment, the Supreme Court, with specific regards to count 7, which does not exist in the laws of this very country, by which the Supreme Court mandated this very court to amend. That hasn't happened. The presence of count 7 on this charge sheet, my Lord, nullifies this entire proceedings completely and totally, because count 7 does not exist in the laws of this very country. One of the points of law, I will make specific references to the ratio that came down from the Supreme Court, where my Lord Lawal Garba explicitly stated that count 7 should be changed. That hasn't been done, my Lord, and this court is in contempt of the Supreme Court binding order.
Oh my God.
My Lord,
Where is this?
the entire argument of the respondent, I'm sorry to say, collapses on just one single point, not many, just one.
Miracle.
The Supreme Court's pronouncement on the standard of the written law is immovable.
Huh?
It is enshrined in the Constitution of this very country,
Oh, that's good. Forgive me.
unless a law is written, unless it is written, defining that very offense, no trial, no conviction can ever take place. And it is my submission, my Lord,
She just
that this very morning,
what?
as we stand in this very hallowed chamber,
This water.
count 7
She just
does not exist.
It's very nice.
And not the repeat laws that will come later. Count 7, my Lord, destroy this entire trial, because Supreme Court gave an explicit order which wasn't adhered to.
The consultant, you have to go to the defendant to tell him the procedure here. We have the practice of front loading. I think he has filed his written addresses in support of all this motion. So he's not to repeat what he has stated in his written addresses, but to state the relief is seek for, and just use a minute each in respect of each motion for adoption.
I'm most grateful, my Lord. I am, without flogging a dead horse, I am asking this very honorable court, my Lord, to please kindly grant my prayers as contained in the motion for reference to the appeal court. And may I also identify the affidavit in support. It is only a 6-paragraph affidavit, my Lord, deposed to by my younger brother, Prince Nnamdi Kanu, also dated the 12th day of November 2025. There is an accompanying affidavit of urgency, which was deposed by my humble self, also filed on the 12th day of November 2025, and also a written address. My Lord, in support of the motion on notice, praying for the orders I had earlier outlined, that too was dated on the 12th day of November, my Lord. May I most graciously ask my Lord to his prayers. Thank you very much.
What about the other two motions?
I should move them at the same time?
Yes.
Thank you.
I've made an order consolidating the hearing of the three motions.
Okay.
Oh, God. I got you.
11th day of November and filed on the same 11th day of November. It is accompanied, my Lord, by grounds upon which this very application is predicated, and the grounds are 4 in number, my Lord, and turn to elucidate the body of objection and then the constitutional foundation and jurisdictional limits of this very court.
You have the ground stated?
Yes, my Lord, you may. Ground number 1, my Lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my Lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to ground 2, my Lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, sub 1 of the 1999 Constitution, and no court had jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder, which is myself. The third ground, any order directing or implying a waiver or final address constitutes a breach of fair hearing, my Lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number 4, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number 4, for reference purposes, my Lord, Section 36(1) of the 1999 Constitution, which I'm sure the court has taken judicial notice of. Those are my grounds, my Lord, in respect of the notice, seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very note be adopted in its entirety.
Come and see what miracle have done.
The third and the very last one is the issue of bail.
Wow. He said the money
Was filed. This was
This one,
dated the 17th day of November 2025. On the 17th.
then if it's this one, now it's better go and use this one now. That card that we have been long time. Do you know if
It is a notice, my Lord, brought pursuant to sections 35(1), 35(4), and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, as amended.
I first tell you.
165
but you said that you have written this one up.
165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I am praying, my Lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of valid charge presently before this court, an order, my Lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence
All because of our
law in fact is unconstitutional, void, my Lord, and for any other orders that my noble Lord may deem fit to make under the circumstance. This is supported by an affidavit, 9 paragraphs, deposed to by Prince Emmanuel, and also by a written address, which I urge my Lord to accept adoption, my noble Lord.
Yes. You moved the 3 applications?
I have, my Lord.
Thank you.
Thank you.
The prosecuting counsel?
The prosecution filed reply to the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply, all '25. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your lordship to dismiss the application because it's a repetition or repetition of the well-worn argument that the counts which the defendant pleaded to are unknown to law. It is for your lordship to determine that in other ones. Well, the one asking for stay of proceedings, my lord, our argument is to the fact that the statute does not permit your lordship to grant any stay or proceedings or injunction. So we ask your lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We asking for the defendant to be admitted to bail on the same ground that to law. His law when he committed the terror. Is also the applicant April 2025. Dismiss all the applications in merit and do not deserve consideration at all.
Thank you. Defendant?
Very simple. My charge sheet currently constituted not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my lord. Finally, I think it is very, very important that I allude to what my lords.
Please, at this point, just ask you.
To explain exactly what the point of law is all about. We respect what you have just said.
Yeah, the point of law.
My lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients?
And on the issue, the matter established jurisprudence by the Supreme Court that stays can be invoked insofar as the issue borders on jurisdiction. Anything we may laid under Criminal Code 45, my lord, is that just Supreme Court determined, my lord, unfair bail. That was their finding. I did not jump bail, and that the revocation of my bail implied that.
It's okay.
Thank you, my lord.
Thank you. Sit down. I'm going to read extempore as the application and all before this court. The defendant filed 3 applications after the matter was adjourned to today for judgments. The defendant filed the 19th day of November 2025, seeking for 2 reliefs. 1, an order admitting the defendant's applicant to bail on liberal terms pending the determination of the invalid charge presently before this honorable court. The second relief is for an order declaring that the continued detention of the defendant applicant in the absence of a valid subsisting charge under a written law in force is unconstitutional and void. The second application is the motion on notice dated and filed on the 12th day of November 2025, seeking for 2 reliefs. The first relief, as stated in this motion, is an order referring certain substantial constitutional questions arising in this trial to the Court of Appeal, pursuant to Section 295, Sub 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The second relief is an order staying further proceedings in the charge, pending the determination of the referred questions by this court to Court of Appeal. The third motion has to do with the notification to file written address. As the defendant stated, he has put in his defense as his right to file written address should not be taken away from him. I've considered also the process is filed by the prosecution in reaction to some of the motions. In the application seeking to refer some questions to the Court of Appeal, the defendant submitted inter alia that the court cannot proceed to give judgment on a defective charge not founded on a written law. Cannot rule on cancellation of. I must say, most of the issues raised here in the application, save the application for bail, have been raised by the defendants severally in these courts. And these courts have made an order that all preliminary objections or issue shall be taken. This court is bound by that order. However, the issue as regards to referral of questions to the Court of Appeal and the stay of proceedings. The statutory law governing criminal procedure in Nigeria, to it, Administration of Criminal Justice Act 2015. By Section 306 of that Act, which provides that Section the Section 306 of Administration of Criminal Justice Act having provided that such application shall not be entertained. This court shall not entertain same. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes application for bail. In this matter, as also stated by hearing has been concluded, and also by the order of these courts on the 27th day of October 2020, the court made an order that the defendant should next date put in his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant's portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised through that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. These courts, in the interest of justice, will not close its eyes to sin. The court will determine all these issues in its judgments. I proceed, I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not permit
the defendants.
My Lord.
Consultants, can you tell your...
My Lord, I will not, please, let me finish.
Please.
It's my case.
I've gone...
It is my case, my Lord, let me finish. My Lord, it is very good. Another idea that everyone was here, my Lord. Another idea that everyone said, and the one thing we can predict and provide a piece of evidence. A piece of evidence. I need to write my comment about my Lord
on the count charge, which reads thus.
My Lord, I'm saying it clearly.
Defendant. Defendant. Can you listen to the court? Can you listen to the court? Please, I beg you to comport yourself.
Show me where it says you can wait
Beg you to comport yourself.
Show me where it says you can wait to family within a place.
You
Show me.
in the
You
name.
are conducting the case for them. You are preparing the case for them. Let them show me the case. Show me where it says you can wait within a place.
You have the right to appeal after my.
No, this is a perversion of the cause of justice. This is not law.
Can you excuse me?
My God, I cannot excuse.
Let him take out.
It's not possible. It is not possible, my man.
Take him.
You must show me where the Constitution says you have the right to vote in the place. Is that important to them?
Please.
Show me.
Please.
Show me.
Excuse me.
Show me.
Get him.
Leave it. I said leave it. This is a court of law. I'm under trial. I'm under trial. I have to speak. I'm under trial. Listen to me. Listen to me, please. I'm under trial. I'm under trial.
Please use the microphone.
Under trial. I'm please. No, listen to me. Please. The judge must listen to me. Wait. I'm asking a very simple question. No, wait. Please, look, this is Supreme Court. Wait, hold on. This Supreme Court here. Hold on a second. I said, hold on. Let me please. May I refer your lordship to section 266 of AGJA? It's not court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me.
Please.
I said, show me. Where you have the right to go to my right to find my address. Show me. It's what the Constitution says. Show me.
Well, I will rise and come back.
You cannot show me.
Can you please take him out? I will come back.
You can't show me.
I rise.
Wait, hold on. Show me where it says you can break my right. Show me the place. Show me. Show me. Which law says you can try me an unwritten law? Show me you cannot show me. You don't know law. Where is it? Which law gave you that right? And you go to try this. You must tell me the press I try. You must. All of you are mad. All of you. What's this one doing here? What are you 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 doing here? This is the that attacked me. That's idiot. That's the fool. I'm going, don't touch me. I'm warning you, don't touch me. I'm warning you, don't touch me. Don't touch me.
ụmụnne m na-afụnụ ya onye a na-egbu egbu ha na-achọ ka okwu Nnamdi Kanu fụrụ idiot ọ sị na enwere idiot many attack o nwere idiot many attack ọ ya ka ọ na-ajụ what are you doing here unu afụnanị ya na ha achọghị isi ndị AIT ha achọghị isi oyi this one ha achọghị isi oyi ka ha achọghị isi oyi ya ọ ya ka ị ga-eji amata ha achọghị isi oyi ya ha achọghị isi oyi ya ha achọghị isi oyi ya ịfụnanụ ekwe ha agbapụ n'ọsọ ha achọghị isi oyi ya ha achọghị isi oyi ya dị na mad reason why ha achọghị isi oyi ha ma ihe ha mega ha achọghị isi they know what they are doing George aha wee ivu ama m eme ha achọghị isi oyi ifu iri ya
media product consumption to the jackboots of authoritarian regulators who do not understand the changes that the digital space has brought upon us. But for us to get that,
tell you, come on, something is fishy. So Nigerian state need a proper reorientation. Those leading us, they have misled this country into a different thing entirely. It's no longer what it used to be.
All right.
The Nigerian experience, as I was growing up, is not the Nigeria I'm seeing today.
Give me a second. Rudolph, I think there's a bit of a. I'm talking to Rudolph in the background. I think there's a bit of lag because on my phone, the court has started. But let me see. Let me put the sound on. Give me 1 second. Can you all hear?
Oh yeah. Can you hear me?
I can hear you, Rudolph. I'm
Okay.
trying to put the audio on for the court. Let me see.
Let me see. It's on here.
It's on now.
Yeah.
I can't
maybe they
hear
are not
it.
speaking yet. Let's see.
No, but on my phone I can hear it.
Okay.
Let me check.
There will be a delay from one side. I'm not sure from where, but okay.
So I can hear on my phone.
Please, Your Lordship. Lord, my name is Adegboyega Awomolo.
Okay.
Senior Advocate of Nigeria. Siraj Saida, SAN. Mutalubi Ojo Adebayo, SAN. SH Bakrum. Abbas A. Olaiwola. Akiyosori Arospain.
Okay, if there's one AI site builder you need to meet, this is Dope Tech from Wix. Now, this whole flow is a conversation, so you're
Preparing for the prosecution, my lord. Thank you, sir.
Thank you. Let me say this. How many people are here as consultants to the convicts? Can you stand up before I call you? You have 4. Okay. Can I meet you? Give them the microphone. You are legal consultants to the convicts. They were lawyers to the convicts before he converted them to consultants.
Yes, my lord.
What is your name?
My name is Dr. Maxwell Opara.
Yes, the next person.
Aloy Jumaka is my name, Lord.
Thank you.
PAN Ejiofor.
Yes.
Prince Mandela.
Thank you. I just want you to be a record that it has a representative in court that will go and tell him, please, you may sit down.
Sorry, my lord. My lord, I don't have his brief to represent him here.
It's okay, you may sit down.
Azeko, please.
My lord, same. We don't have his brief.
Why are you here?
We are here as consultants, my lord.
I'm coming. This morning, when we started, you acted as consultant. You went to him, tell him to inform the court. I have the video here. You moved from that place, you went to the convicts. You told him what to say. And I have to say this.
I have to take your direct instructions and directives.
But you are the consultant, are you not?
I am.
Thank you.
But we don't have his brief.
It's okay.
In the real sense of it.
So it's okay. I'm just telling you so that you go and send him tell him this sentence. And I must say this. It is becoming getting to a level that I have to say this.
In some kind of legal jeopardy.
You may sit down, please.
Thank you, my lord.
Thank you. Sentence. I read the entire file from the time the matter started in 2015. No doubt, the convict has not acted well throughout this period. He has caused delay severally. He caused delay and started crying that he's held unlawfully without trial. And also, his unruly behavior from the beginning down today, even today, is noticed. However, this court will not consider that in sentencing, as our God himself is merciful. He has been convicted, and this court is only being merciful to him because we have to be merciful as enjoined by our Lord Christ, Jesus Christ. The court is minded to sentence the convicts to death due to the atrocity he committed. The convict has not shown any remorse whatever for his actions. He remained arrogant, cocky, and full of himself without realizing the magnitude of his crime and the effect of what he has done against his people in the Southeast. I've listened to the allocutors made by the member of House of Representatives representing the constituency of the convicts. Although I'm not really persuaded, but I must temper justice with mercy. The court is moved by chapter 23, verse 23 of Matthew, in the book of Matthew, to the fact that who unto you, scribes and Pharisees, hypocrites, for you pay tithes of mint and anise and cumin, and has omitted the weightier matter of the law, judgment, mercy, and faith. This you ought to have done, particularly, and must notice the words in Matthew 23 and verse 23, the word mercy. Our Lord himself is merciful. No matter what we do, is a merciful God. It is on that note that the court will follow this above admonition of Jesus Christ in the post passage and show mercy to the convicts. In addition, the death penalty globally is now being frowned upon. by the international community. Consequently, and in the interest of justice, I hereby sentence the convicts to life imprisonment for the said counts 1, 4, 5, and 6 instead of death sentence. Life is sacred to God. With respect to count 3, he is hereby sentenced to 20 years imprisonment without no option or fine. For count 7, he is sentenced to 5 years imprisonment without no option or fine. To extend the mercy, I hereby order that the sentence shall run concurrently. And due to the nature of the offenses that borders on terrorism and the attitude, violent nature of the defendants that I have taken judicial notice. The last adjourned date, he was so unruly and expressed violence, even was about to beat the security officers here. This morning, he repeated same. That has been his trait, his attitude. So I have no hesitation in coming to the conclusion that convicts has the tendency of violence. The tendency of violence has not left him. It is based on this that he must be kept in facility that is suitable for his custody, as putting him in Kuje Correctional Center may not be appropriate. And also, I take judicial notice and that from conclusion of the judgment and from the exhibits that I've analyzed in my judgment, substantially, the convicts made use of computer device like phones in making broadcasts to incite and call for all these atrocities. It is based on that without hesitation, I agree with the counsel to the prosecution that the convicts must not be allowed near any digital device, and if he must be closely monitored by the Office of the National Security Advisor. And also, with the atrocities, the number of killings, and the effect of the acts of the convicts on the people of Southeast, I think it deserved protective custody. Due to this offense, I ordered that if the convicts be kept in protective custody in any custodial center in any part of the country. And also, the objects of crime in respect of count 7 that has to do with the transmitter. The transmitter is hereby forfeited to the federal government. Thank you. Thank you. And regards other exhibits, if at the expiration of the 90 days, the statutory time for appeal. If there is no appeal, an application may be brought for necessary consequential order. Yes, thank you.
Let me again, on behalf of the people of Nigeria, thank the judiciary for this development. It is now clear that law has its consequences, and anybody who breaks the law must be ready to face the consequences. And besides, law must be obeyed for the peace of the society. Law and judicial institutions must be respected to avoid anarchy and lawlessness. I want to thank you again on behalf of the people of Nigeria, the judiciary, for this judgment. I hope and pray that many others will still learn from this decision. And I pray also that the Lord will give you health, strength, and advancement in your career. My Lord, 9 months has been very challenging. I'm grateful to your Lordship.
Thank you.
We on this side.
Once again, the next 15 minutes, you can collect the certified copy of the judgments. Thank you. All right.
Congratulations. Thank you.
Ewo, ụmụ Biafra, unu afụnanị ya nụ. Unu afụnụ ya o. Unu afụnụ ya. A sị na ọ wụ life imprisonment.